Generally, the interpretation of an arbitration clause in a written contract, including whether a particular issue is arbitrable, is for a court to decide. In the 1985 case Mitsubishi Motors versus Soler Chrysler-Plymouth, the United States Supreme Court considered whether federal antitrust claims arising out of an international transaction were arbitrable under a valid arbitration clause. Mitsubishi Motors is a Japanese corporation that manufactures automobiles. Mitsubishi was also the product of a joint venture between Chrysler International SA, a Swiss corporation, which we'll call CISA, and Mitsubishi Heavy Industries, a Japanese corporation. The purpose of the venture was to distribute through Chrysler dealerships outside of the continental United States vehicles manufactured by Mitsubishi and bearing Chrysler and Mitsubishi trademarks. Soler Chrysler-Plymouth is a Puerto Rican corporation operating Chrysler dealerships in Puerto Rico. On October 31, 1979, Soler entered into a distributor agreement with CISA under which Soler was to sell Mitsubishi-manufactured vehicles. On the same day, CISA, Soler, and Mitsubishi entered into a sales agreement which provided for the sale of Mitsubishi products to Soler under specified terms. The sales agreement included an arbitration clause that stated that all disputes arising out of or in relation to the sales agreement were to be settled by arbitration in Japan. In 1981, the new car market slowed, and Soler sought to delay or cancel the shipment for approximately 1,000 vehicles. Subsequently, Mitsubishi sued Soler in the United States District Court for the District of Puerto Rico, seeking a court order to compel arbitration. In response, Soler counterclaimed for antitrust violations, including violations of the Sherman Act. The district court ordered arbitration, and Soler appealed to the First Circuit Court of Appeals, which affirmed in part and reversed in part. Specifically, the First Circuit reversed the order of arbitration as to Soler's antitrust claims. The United States Supreme Court then granted cert.